Perhaps one of the most stressful times for an employee is when they get sick, or they need a surgery, or they're having a medical problem. And employees fear that if they take time to care for themselves or a loved one, such as a husband or a child, that they're going to lose their job. No employee should be faced with making the decision to care for themselves or care for their family or their job. Under California, employees are protected from being discriminated against or being terminated because they take leave to care for their own serious health condition or that of one of their family members. Under California law, employers who have more than 50 employees within a 75-mile radius, if that employee has worked for 12 months and over 1,250 hours within those 12 months, the employer must grant up to 12 weeks of leave to that employee to care for themselves or their close family member. Now that 12 weeks doesn't have to all be taken at the same time. It can be what we call intermittent leave. So for example, if there are appointments with doctors or there are the requirement to take off time and only work 4 days a week instead of 5 because of an illness or injury or the need to care for someone, then the employer must give that time intermittently. Now an employee needs to try to give their employer as much advance notice as possible. But if an employee can't because of an emergency, then the law states that they have to contact their employer as soon as possible. An employer can ask for an employee to have their doctor certify that they're having a serious medical condition, and they can ask for certain forms to be filled out. Those forms should be filled out and returned if you want to have the benefits of the medical leave. At the end of your medical leave, your employer has an obligation to return you to the same or similar position that you held prior to your medical leave. And an employer cannot take away your job for having exercised your rights to these benefits. Now, something that's interesting to understand for women who've undergone pregnancy is that they may have rights to their pregnancy leave as well as their family right leave, meaning that they can have the rights that they're given under the pregnancy laws, which we talk about elsewhere, as well as having this extra period of time if they themselves have suffered some sort of pregnancy-related disability, which is quite common. So that can extend the total time to a pregnant female up to 7 months of combined time for pregnancy leave and family medical leave. If you have a need for this leave, consult with your HR department. Make sure you put it in writing that you want to take medical leave. If it's denied, then you should contact an attorney. And something that's particular to California law is that your employer cannot interfere with your rights for medical leave, meaning they should not be trying to get you to work while you're on medical leave. They should not be trying to get you to come back early. They should allow you the time that you need to heal or care for the ones you love. So if your employer violates these rights, contact us. We will guide you through the steps to make it right.